Coburn against Polk County Board of County Commissioners. This is a workers' compensation case, the next case. Ms. Laquasto.
May it please the Court. Good afternoon. I'm Wendy Laquasto of Fox & Laquasto. I'm here today representing appellant Bobby Coburn, who is a claimant in this workers' compensation appeal. I'd like to reserve 2 minutes for rebuttal. The briefs raise two issues. The first has to do with the denial of a May 2009 petition for benefits based on the statute of limitations. The second issue deals with attorney's fees and costs, because the second issue is a derivative of the first. Unless the Court has specific questions concerning that issue, I'm just going to rely on the arguments in the brief.
Counsel, as you know, since the briefs were filed, we've entered a case, Gore v. Lee County School Board, that addresses the issue really before us here. I'd like you to talk about Gore for a minute, but also focus on whether the hearing aids here are sufficiently like the device installed in the knee in Gore and the back brace, and I think it's Fuster, so that those cases would govern here.
Yes, sir, and that's pretty much my argument, is that I think Gore requires reversal.
I had a question mark at the end of my question, Counsel.
As you said, it was Gore was released after the briefs was filed, so we didn't have an opportunity to discuss it, and I figured it would be a topic of discussion today. I think this case is a case of first impression concerning hearing aids as prosthetic devices, and so to that extent, Gore is not controlling, because that has to do with a knee replacement and prosthesis in the knee. So it is different, but it is the case law determine. I don't know that there's actually a case that says a hearing aid is a prosthetic device, but that has been said in cases that don't deal with hearing aids.
The firm's been very successful in pushing the boundaries of prosthetic devices over the last couple of years.
Well, I think there probably were tried to be more successful when there used to be an exception for it, but I don't think they're quite as successful now, corneal implants and things like that. But I think one of the Supreme Court cases that talks about prosthetic devices puts hearing aids in the same category as artificial limbs, and so I think case law has pretty much established that it's a prosthetic device, and I think counsel would agree with me that no one disputed that the hearing aids were a prosthetic device here. I think the court...
Didn't the JCC find it was a prosthetic device? I remember that from the order?
Yeah, and she said that that's care. And I think that that's consistent with the case law, that prosthetic devices are care. I think where Gore takes this to a new level is that it makes that analysis. It really kind of answers the question what the 94 amendment that took away the exception for statute of limitations on prosthetic devices did, and that's really what Gore did. It said, okay, you're not going to automatically have a tolling just because you're a prosthetic device. We're going to apply the medical device tolling exception in these kind of situations. And if the claimant is using the medical apparatus or medical device, which is the prosthesis, on a continual basis with the employer's knowledge, then that's going to be sufficient to toll the statute of limitations. And that's what Gore held, because this claimant there was continually using her prosthetic knee device, that was a tolling of the statute of limitations, and it never expired. And so her petition was timely when filed. And by analogy, that's the argument that I'm making here, is because Mr. Coburn continuously used the prosthetic hearing aids from the time he received them in 2003 through the time he filed his petition in May 2009 and beyond, that there was a continual tolling of the statute under Section 440.19 subparagraph 2, so the statute never expired. And that's the mistake as a matter of law that the JCC made in this case. That's the same mistake that was made in Gore, was the JCC determined the statute had expired when there was, in effect, a tolling.
Under Gore, the employer carrier was, the claimant was required to show that the employer carrier had actual knowledge that the claimant was continuing to use the prosthetic device. And in fact, Gore sends that back on remand for determination of that issue. Is that a similar situation here?
Yeah, I argue that in my briefs. I mean, I think the Taylor case, which came before this, was also a situation where the judge does not address the actual knowledge to determine the tolling, whether claimant successfully carried that burden to show the tolling, that it's a reversal and a remand with specific directions to consider that. And I think that's exactly what needs to be done here, because that the statistician never addressed the issue of whether the employer carrier had actual knowledge that Mr. Coburn continued to use the hearing aids.
Does the records substantiate a finding that based upon the, I guess, did he last get his batteries, what was that, in 2006?
2006.
I guess, did the employer intend to buy a 2-year supply of batteries at that time?
According to Mr. Coburn, his calculations, he received batteries for hearing aid in 2003, and when he went for a new hearing in 2005, a new hearing aids in 2005, he wasn't asking for new batteries, he was asking for new technology. And based upon his course of usage, he understood, and he submitted calculations that showed that these 80 batteries that he received in 2003 would be, if he used his hearing aids, you know, as they should be used, both of them at the same time.
He alternated the years.
Yeah, he had other...
But he could have taken a day or two off every now and then and really extended this out.
Right, he could have, but, you know, our argument is that if you use them, like the Ginsburg, if you used your remedial treatment as you should, which was 2 years, these 80 batteries would last 2 years, that if he had used it according to that, then he would have been using it as prescribed. And that's how the Ginsburg thing comes in terms of extending the remedial use. But he testified that it was 2 years worth of use. But I don't think, you know, this case was tried under a different theory because we didn't have the benefit of Gore when we tried this case. I submit that if Gore had been available when everybody had tried this case, that the arguments would have been a little bit different, because Lowe had to rely on the batteries to some extent. But he did argue below that use of the hearing aids and the batteries were remedial treatment that told the statute, and I think that issue is presented here for y'all to decide. And our position is that Gore requires reversal and remand with directions to make findings on specific knowledge and determine whether a claimant satisfied his burden of proving that the statute of limitations was told under subsection 2 of 440.19. If you have any other questions, I will reserve the rest of my time for rebuttal.
Thank you.
May it please the Court. Tom Vecchio of Lakeland with the law firm of Ross Vecchio on behalf of the appellee, Polk County Board of County Commissioners and Commercial Risk Management. As counsel pointed out, the Gore opinion was rendered after this case had been fully briefed, and Gore obviously changes the landscape of the argument that we are here to address today. But Gore, like all of the relevant cases before it, always emphasized the necessity of employer-carrier knowledge with respect to the injured worker's use of a medical device or a prosthetic device. And I noted both medical device and prosthetic device.
That knowledge thing, doesn't that really come out of the Fuster case, the back brace?
Yes, sir.
And can't you see a difference in a back brace that a doctor may say use as needed and a hearing aid?
In part. And the reason I say that in part, Your Honor, is the claimant's argument was that the employer-carrier should have presumed that he was using his hearing aids on a daily basis or regular basis. However, from my client's perspective, we have an older gentleman who resigned from Polk County, and I don't believe it is a foregone conclusion that he would use his hearing aids on a regular basis, if at all. There is no suggestion or record evidence that Mr. Coburn would have suffered any adverse health effects whatsoever had he not used his hearing aids.
Shouldn't you, though, be held to some sort of standard to presume that he would have used them at least? We're back in the 2-year statute, I think, in this case, aren't we? Or in the 1-year statute?
The 2-year, 1-year statute.
2-year and 1 year.
Yes, sir.
He would have used them on a monthly basis or biannual basis or something like that.
Well, Judge, that foreshadows an argument that I am going to make with respect to the problem of applying the reasoning in Gore to the facts of this case. And what I believe is a very, very important distinguishing factor in Gore is that Ms. Gore had a knee prosthesis. She obviously could not do anything to this knee prosthesis without recourse to an orthopedic surgeon. Unlike Mr. Coburn in this case, and unlike the claimant in the Lee versus City of Jacksonville case, who was using a TENS unit, this is the type of thing that the injured worker can use or not use at will. Ms. Gore obviously was unable to remove her knee prosthesis on her own, but Mr. Coburn in this case even removed his hearing aid during the course of the final hearing.
This begins to sound like the problems I identified in my dissenting opinion in Ginsburg.
And that is precisely one of my points, Your Honor. Your Honor indicated in
But, that opinion did not carry the day.
I thought it was a concurrence, Your Honor, as opposed to a dissent.
I'm sorry, a concurrence. But in that opinion, I concurred solely because prior case law bound me to concur, and I noted that these kind of factual questions are just very, very difficult to determine, but
and that is
again,
why
that's not the law.
And that is why Your Honor suggested that a bright line determination with respect to the tolling or running of the statute of limitations was the preferred method in which the court ought to view such an issue. Now, the problem that I have
But
with...
there's no case law to support. I mean, I noted those problems with making these factual determinations in statutes of limitation context. But in that opinion noted that the prior case law required these kind of factual determinations. So here, I assume, is your argument that in light of Gore, a remand is necessary and a factual determination about when he used the hearing aid?
I do not believe that is warranted in this case because that issue was addressed in the claimant's deposition of Mr. Siderio, the claims adjuster responsible for administration of this case. In retrospect, it's easy to look now and realize that the claimant did not drill down as deeply as maybe he should have in questioning Mr. Siderio. However, the notice requirement is not new with respect to Gore. The notice requirement is something that had been the law of the land throughout all of the cases prior to Gore and including Gore. Now, with respect to a point Your Honor made a moment ago about weekly or biweekly or monthly use of the hearing aids or the prosthetic devices, the problem with that, as applied to the facts of this case, is there is no evidence regarding employer-carrier knowledge. The claimant suggests that the employer-carrier should have known or could reasonably have expected this gentleman to use his hearing aids on a regular basis, but there's no evidence to that effect. So
how could there ever be? I mean, this is not like a TENS unit or a back brace that are used PRN for symptoms. You have a bad back, you use the brace twice a week. If you're on an airplane, you get a TENS unit, it flares up. Perhaps the issue wasn't fleshed out, but it just seems like a hearing aid is something a little bit different. I'm not going to go as far as to say don't leave home without it, but if you're going to go to the trouble to get one, I don't see how the employer-carrier can say, well, gosh, we had no idea he was using his hearing aid. He's deaf. He got deaf on the job 18, 19, 21 years ago, whenever it was. But
well, there's no suggestion that Mr. Coburn is deaf. And, in fact, he testified at deposition and at trial that there were certain frequencies that he had a hard time hearing. He was running a business from home in terms of what he said at trial, some kind of insurance consulting or something along those lines. But if we are to allow a claimant's ad hoc use of a medical device or a prosthetic device with no notice to the employer-carrier suffice for purposes of extending the statute of limitations.
I guess what I'm suggesting, and it may not be something we reach in this case, you hit the nail on the head when you said ad hoc use, because that's exactly the way I would characterize a TENS unit. I just don't buy that for a hearing aid, though. This guy's got a noise-induced high-frequency hearing loss. He is never going to be able to hear those frequencies. So it's not just that he can't hear them on Wednesday and Saturday. I don't see how, I guess what I'm saying, counsel, is I don't see how your client is all that prejudiced by this.
Well, Judge, and here's where the prejudice lies. If we were to accept the claimant's reasoning on this point, that his inconsistent and somewhat sporadic use of his hearing aids, which is borne out in the record, he testified that the only time he used both hearing aids simultaneously was when he was at church. And he testified that he generally used only one, and sometimes he used no hearing aids at all. So if the claimant's unpredictable or irregular use of hearing aids constitutes medical care sufficient to extend the statute, then an injured worker with a prosthetic device or medical device could use that device once a year for decades and say, I received medical care once a year in accord with the statute.
I hate to belabor it, but I'm still not satisfied that a hearing aid is directly transferably comparable to a back brace. That's my only point.
I understand that.
Back brace may only be used once a year. Certainly you can go 4 or 5 months without using it if you have a bad back.
Well, and Your Honor, that brings me to a point with respect to the relief requested by the claimant. I believe that the greatest degree of relief that the court could accord to the claimant in this case is a remand for more specific findings.
But counsel, let's go back. It seems to me the argument you're making goes to the nature of the prosthetic device that's involved. It seems to me if a claimant receives a prosthetic device to address a medical problem that arose out of an industrial injury, and that there's a medical necessity for that, then common sense would say that it would be, and it's necessary, it would be used. Now, it may not be used all the time, but it's a different situation, as Judge Kahn observed, than a back brace that is used only when you have a sore back or your back is flared up. Why shouldn't the line be drawn on the nature of the prosthetic device?
Because in my estimation, the Gore opinion blurred that line. And my recollection of the reasoning in Gore was that there was no reason for this court to consider a medical device, like a back brace or a TENS unit, any differently from a prosthetic device with respect to tolling of the statute of limitations. And I believe that the Gore opinion blurred that line between a medical device, such as a TENS unit or a back brace, and a hearing aid. So I believe that for that reason, the Lee versus City of Jacksonville case becomes more appropriate, because that involved use of the TENS unit. And the Supreme Court held in Lee versus Jacksonville that the notice requirement was paramount.
But I guess don't we really, I mean, you do this kind of law, I did this kind of law. Don't we really know what's going on in the back brace TENS unit cases? Essentially, if you don't have a strict notice, awareness, whatever you want to call it, requirement, the claimant completely controls the statute of limitations, right?
I'm not sure I understand the
question. The claimant can come in, and say, I've got this back brace, it's going to last 20 years. The statute's told for 20 years. But with a hearing aid, we'd have to indulge this sort of bizarre presumption that a person who's got a significant hearing loss is just not going to use the hearing aid.
Well, I don't think we can infer anything one way or the other. But I think that what we do have is a circumstance where the claimant is asking the court to condone his failure to provide notice to the employer carrier. And the claimant never suggests how long the statute of limitations should be in this case. We don't know whether the claimant is suggesting a 2-year statute of limitations or whether it's 4 or more years, because according to Mr. Coburn's own calculations, the supply of batteries that he was given in August of 2006 was enough to last him for over 4 years. That begs the question, why did he allow more than 1 year to elapse before he went back to the medical provider, yet scheduled his appointment to occur 3 months before that 2-year deadline? Mr. Coburn testified that he was laboring under the false assumption that he had a 2-year statute of limitations, when in fact it had been constricted.
So you're complaining because he saved your client money by not going back to the doctor every 6 months. Which is what we get in some of these statute of limitations cases, quite frankly.
And I'm
we get the
suggesting
employer carrier complaining that the plaintiff just wasn't diligent enough in getting all this medical care, and therefore the statute ran.
There's no other way to address that, Your Honor. This is a purely legal system and not equitable. In the 15-plus years I've been doing this, this is the first injured worker I've ever had concerned about saving my clients any money. So I
But
think that...
let's go back to the prosthetic device in the knee of Ms. Gore. She may not need to go to an orthopedic surgeon concerning that device for years. Why should the statute run at all?
Because of the necessity of employer-carrier knowledge and the reasons why we have statutes of limitation in all forms of civil action. The employer-carrier must have some opportunity to investigate and must have some ability to determine what is going on with that injured worker, because if not, then we're going to end up with very, very difficult claims where an injured worker says, it's been 20 years since I've ever risen on the employer-carrier's radar, yet now my total knee replacement needs to be revised. And as a practitioner, we see medical opinions after reports after reports where the physician says, Mr. Smith is here for his yearly visit to keep his statute of limitations open. My argument was, had the claimant done that, we wouldn't be here today. And I believe that is obliged.
Thank you. Thank you.
I think that it's important to, the employer carrier here has maintained below and on appeal that it didn't have any knowledge that he was using the hearing aids. And I think when you look at the definition of prosthesis, it's a replacement for a defective part of a body. And I think that there's a lot to be said in Judge Kahn's suggestion. It's like, why don't we just assume that somebody is using something that replaces a defective part of their body? And then that's exactly what J.C.C. Jenkins question in the hearing too. I think that it's important to note that that this man reported his hearing aid and hearing loss in 1999, and that was determined compensable in 2002. He didn't request a hearing aid until 2003. So after he was retired, 4 years after he retired was the first time he requested a hearing aid. He asked for batteries for it. He asked for a new hearing aid in 2005. He asked for batteries again in 2006. So I think that there's a course of conduct here by claimant that demonstrates that, and the employer carrier provided all of that the employer carrier had knowledge that this man was using his hearing aids. He wasn't just, as I said in my brief, sitting home in a world of silence, not using his hearing aids. And I think that there is evidence in the record to show that he did that. But
this is where the math sort of comes in here, because with an implant, with an actual false or manufactured joint, that may go way off into the future. But how long does it go with the hearing aid that's dependent on replacing batteries? If there's some sort of presumption, which
I think that. I think that this man did replace his hearing aids once already. Now, that was because there was a new technology, and that's the reason he tried to go back to the doctor in 2008, was because he wanted to see if there was something new. I don't think there's anything in the record about hearing aids wearing out like there was in the Gore case about knees wearing out. But I think that the language in Gore about a prosthesis, I think it recommends that's a common sense. The interpretation recognizes that a medical apparatus such as a prosthesis can require further treatment treatment at any time after its insertion into the body. They're designed, and that the workers' compensation system is designed so that industry bears the costs of maintaining these prostheses. And so that's the reason that Gore comes out the way it is. You've got something that's a replacement of a body part. When it falls apart, needs to be replaced, wears out, that it's the industry that should replace that because of its very nature. And that by requiring claimant to repeatedly say, I'm using it, shifts the burden to monitor the system away from the employer carrier, who could have sent the claimant, are you using your hearing aid, are you using your hearing aid, questions. And you're talking about shifting the burden here from the industry that caused the hearing loss to claimant. And so for these reasons, I reiterate that there are no findings on actual knowledge on the part of EC here, and you'd be stepping in a fact-finding role to be able to make that. So I think you really need to reverse and remand. No further questions. Thank you so much.
Thank you. We'll stand in recess.